doing well. I've missed you. You're probably not surprised, but nothing is working. I'm working on it, but nothing is working. Um, there's no, there's no camera. I'm not gonna have a camera at all for this because it's not working right. I hope you can hear me. Um, but I'm gonna talk to you through chat only. We're gonna start with Judge Ford. He will make us all feel better. It's been a while. You guys have so much to tell me. You guys, I missed, 5 days in a row. Yeah, it feels muffled because nothing is effing working right now. Nothing. I don't know how the music was fine because, oh no, YouTube is giving me a big yellow error. You know, YouTube can F my D. Okay. I need to hear in chat everything you guys did over the week. I'm gonna play this freaking video.
Are you Edward Mueller?
Yes, sir.
Your home address, please.
I don't have a home address. I'm homeless.
Right. Is there an address where you can receive mail?
No, sir.
Okay. What's your date of birth?
5559.
And how old are you now?
67.
You read, write, and understand English language?
Most of the time, I don't understand everything. I have mental problems and I have learning disabilities, Your Honor.
Well, if I say something you don't understand, let me know, okay? How far did you go in school?
10th grade, but what does that matter mean?
Oh, I'm just curious.
You know, it doesn't matter. You know, people can be intelligent.
You probably have the influence of any drugs or alcohol.
No, Your Honor.
Please listen while state reads the charges and possible penalties.
Thank you, Your Honor. On or about the 7th day of June, 2026, in the County of LaPorte, State of Indiana, Edward Euler did unlawfully, knowingly, or intentionally, while not having a contractual interest, enter the real property of another person after having been denied entry by the other person or that person's agent. This is a Class A misdemeanor punishable by up to 1 year in LaPorte County Jail and a fine of up to $5,000.
I don't understand that, Your Honor.
Okay, we'll read it again.
While not having a contractual interest, enter the real property of another person after having been denied entry by the other person or that person's agent. This is a Class A misdemeanor punishable by up to 1 year in LaPorte County Jail and a fine of up to $5,000.
I still don't understand that.
Well, Edward, we'll bring it back in a week and see if your understanding's any better.
Well, I still won't understand it then, Your Honor. I won't understand it then, and I won't stand it under 10,000 years from now because I don't understand it. Do you understand that?
You're excused.
All right, that was all we had for the
The probation department saying tested positive, have a seat, tested positive for amphetamine and methamphetamine. That you were ordered to complete a domestic violence counseling program. Let's see. That you completed the initial contact with Oakland, but no further contact. Oakland. You didn't begin your domestic violence counseling program. You didn't pay your fees. Failed to report change of address to your probation officer. Is there anything you did?
Yeah, I'm trying to reinstate it.
Well, okay, so here's the deal. This is a so you want a lawyer appointed. What you're telling me is you'd like to have a evidentiary hearing. What I mean by that is having, state would have your probation officer come in and testify that you didn't follow through on the thing you were supposed to. And your lawyer could cross-examine these people, and otherwise say, hey, you did everything you're supposed to. That's one option, but you have to qualify for that, for me to appoint a lawyer. If you want to work out something with the state, quite frankly, the state doesn't really have a say in the probation violations, really between you and the court. But if you want a lawyer to represent you or trying to work something out or trying to argue your case to me, I'll give you time to hire a lawyer. The third option is to represent yourself. So what would you like to do? So
What do you mean by represent myself?
being your own lawyer. You want time to think about it?
I can do that.
Okay, well, I know you can. Do you want time to do that? All right, so what would you like to do?
I'm trying to get my classes reset. I'm not getting out.
Okay, so, well, we're not there yet. So what do you want to do? Do you want me to appoint a lawyer because you want an evidentiary hearing? You want time to hire a lawyer? Or would you wish to represent yourself?
Represent me doing,
You want to represent, you want what?
if you can represent me a lawyer or something like
You
that.
want me to appoint a lawyer for you? So you want an evidentiary hearing on the issues that the state allegedly violated? No? Okay. This, again, let me repeat. This is a civil matter. Okay? You're not necessarily entitled to have a lawyer represent you because it's civil in nature. Unless you want an evidentiary hearing where the state would have witnesses come in or present some sort of proof that you violated your probation. You could your lawyer could cross-examine these witnesses and such. That's one way to go, but you have to qualify. May make too much money for me to appoint a public defender. Your second option is I will give you time to hire a lawyer. Okay? You would like time to hire a lawyer. How much time would you like?
Yeah, I'm working on getting a job right now.
Well, that's not very promising for hiring a lawyer. If you don't have any money, how are you going to hire a lawyer? They don't work for free. How are they going to work? Yeah, see? So your options then, sir, I'll give you time if you want. If you've got some source of income that I'm unaware of that you might be able to tap into, I'll give you time to do it. But if your only source of income is you and you don't have a job, I think it's kind of wishful thinking on your part that you're going to be able to hire a lawyer.
I had a job interview before I went to probation at night in Plymouth,
Right?
and I got arrested, so I couldn't get time to go to my interview.
Uh-huh. Well, they're probably not going to hire you if you didn't show up. So, any other job prospects on the horizon?
I got another one that's waiting on me right now. It's called.
Well, okay, all that's assuming that you get out of jail, right?
Yes.
Because right now you're not being held on a bond, right? So what could you afford by way of a bond? You don't know what you could afford?
$250. I can get out for $250.
So if you could afford a $250 bond, my guess is that you can't afford to hire a lawyer. I'm just being real. Let's be realistic here.
Yeah.
But will give you time if you'd like. I'm not sure we're going to set the bond at $250 though, so might be higher.
Yeah.
Good with that?
Yes.
All right. So how much time do you think you'd need, assuming that you were going to hire a lawyer? How much time do you think you'd need? I'll tell you what I'm going to do, sir. We'll set this over to July 8th. That'll give you time to hire a lawyer. Say what's your position on bond?
Judge, it looks like he has 7 prior felony convictions, 3 of them domestic violence. So the state would request no bond.
Well, then we have to have a hearing in the next 14 days on the application. So here's what I'm gonna do, sir. I will set the bond at $500 cash, $5,000 for maturity. Your next, if you're able to bond out, you need to be back here in July 8th. If you aren't able to be bonded out, that'll tell me that the odds of you ever hiring a lawyer on your own are probably slim to none, and we'll set up for an everyday treatment. All right?
Listen,
So, if and when you bond out, sir, you need to report to the probation department here in St. Joseph County and check in with them. I will give you until noon the following day after you post your bond. If you fail to report, that'll be a violation, another violation of your probation. Understand?
yes, sir.
All right. You know when your next court date is?
July 8th.
At what time?
Mine?
Yep.
Okay.
See you then.
See,
Guys, you need Miss Monterosa out here.
Huh?
You need Cecilia Monterosa here. You don't know
For what?
That's when we go. Move that.
We moved that one.
Okay. got it.
Yep, we moved.
Okay.
Yep.
I don't think that. I might be there fine with that.
Executive, go tell them.
Is he reporting for pretrial then? Is that what you got him on?
Yeah,
All right.
that's not pre-trial. The probationary.
Okay, okay.
All right, Mr. Mattingly, you saw my order, right? Is Miss Barnes here?
Yes, she is. Was Barnes.
All right, court will next open the record in 26 CR 9, People versus Lane Nicholas Rothman. Mr. Rothman appears by WebEx from the Bakke County Jail, is assisted for today's purposes by Miss Madeline Almond. Miss Esch on behalf of the people. Miss Almond, are you similarly able to waive Rule 5 advisement for Mr. Rothman?
Yes, I am, and I do so at this time.
Thank you. Court accepts that, and we'll move to the issue of bond. This was a menacing allegation, so the court
Okay. This is 46 DO2 9903 JP 79. Mr. McDonald, can you hear me okay?
I can, Your Honor. Can you hear me okay?
Absolutely. And who do we have online? Is it Mr. Nesby?
Yes, Tyrone Nesby. Yes, Your Honor.
All right. Mr. McDonald, what are we here for today?
Well, I believe it's Mr. Nesby's petition, Your Honor.
Yes.
It is, but my computer's a little slow, so.
Oh, well, he filed, sure, you bet, Your Honor. He filed what he termed essentially, well, there were two things. Let me flip to the most recent. It was, I think he called it an interlocutory appeal based on the substance of it. And I don't mean to speak for Mr. Nesby. He can certainly cut in and correct me, but
no problem.
I would argue that based on the substance of what he wanted, which was seemingly questioning the very finding of paternity, I think primarily, and then getting into the arrears calculation, et cetera, I would call it a motion to set aside because we're dealing with an order that's been in existence for quite some time, Your Honor. But that's the preliminary issue, is his, I think, questioning the issue of paternity. Moving on from that, questioning maybe the calculation of arrears that our office has prepared and have existed for some time now, Your Honor. And this is an arrears only case at this point, Your Honor. We're well past the emancipation of the child.
Yeah, I don't see a lot of 99 cause numbers anymore.
No.
So Mr. Nesby, where are you currently located?
in Las Vegas.
And what's your current address?
It's P.O. Box 400. I'm sorry. Yeah, P.O. Box 400 212. That's Las Vegas, Nevada. 89140.
And you filed a couple things, and I think Mr. McDonald was correct. We're all a little confused by it because I'm aware you're not a lawyer.
Yes.
So you didn't quite file the things we're used to seeing filed, but what is it fair to say what you're asking in your interlocutory appeal, that you want to set aside the paternity? Yes, Sean. I was just basically asking the court to show like proof of service. I wonder if the court can show that today, and the proof, the documentation of the paternity.
And Your Honor, I can respond if you'd like.
Yes, my computer's finally working now, but you may respond.
Thank you, Your Honor. I would point out, that we are dealing with an order that is over 27 years old at this point, and an emancipation that took place 11 years ago. I bring that up because, as Your Honor knows, if Mr. Nesby is essentially, I get he wants proof of this, and isn't really saying I'm wanting to set aside, but there's no other purpose to providing proof other than to try and set aside the judgment. And Trial Rule 60 under the Indiana trial rules requires that a motion to set aside be accompanied by some type of meritorious defense or proof of a meritorious defense, but generally speaking, be filed within 1 year of the date of the judgment, which again would have been dating back to 1999. There are circumstances, as the court knows, that would allow such a motion to set aside within what the court or what the trial rules call a reasonable time. I guess from the state of Indiana's perspective, and having a lot of years in doing this, I would argue that certainly we are not within 1 year. That would have run in year 2000. And I don't consider 27 years plus a reasonable time to be filing a motion to set aside the issue of paternity. So I would ask that the court summarily dismiss anything related to proof of service or proof of paternity or DNA testing, et cetera, because without getting into the merits of that question, the time has long since passed, Your Honor.
Any response, Mr. Nesby?
Yes. Well, I was looking over the files that they sent me that they filed in 1999. I was just looking over it, and they put an address there that I have not stayed there, so I was never properly served. So if I'm not properly served, then how will I even know? Well, also for them to have personal jurisdiction over me, I have to at least be properly served. And I was not. The addresses that I have, I can send them over. There's 2 addresses that I stayed at in California when I was playing basketball there. And it is not that Figueroa or whatever street address that they had. So I never received anything.
And that's getting more towards the substance of the argument rather than the issue that we're 27 years down the road.
And Your Honor, it's 27 years, but if I didn't know anything about it, then how can I respond? That's part of due process.
And again, Your Honor, I don't want to get into necessarily the substance. We feel that the 2 substantive orders that took place in the state of Indiana both have adequate proof of service, both noted in both instances by Judge King, your predecessor. And secondarily, with regard to the I don't have notice argument, there were multiple hearings in this matter. We had this case shipped off to St. Joe County when there was a conflict with the elected prosecutor for many years in the mid to 2016 to 2023. But beyond that, there were payments made. There were substantial payments made in 2022, 2007, 2009, 2013, et cetera, et cetera. So the argument that we didn't have jurisdiction or that he didn't have knowledge is just not represented by the facts of the case.
And can I respond, Your Honor?
You may.
Yeah, and if they was, I personally didn't make any payments. I was coaching high school basketball the years that he's talking about, and they just report. They just sent me like a letter. They sent to my office and just said that we're going to be garnishing money from your check due to child support. They never gave me who the money is going to. I had no recollection of anything about that. So again, I did not know.
I appreciate that, sir. I'm going to deny your motion to set aside this based on lack of service. What other motion did you want to argue today?
Wow. So, Your Honor, again, if I was never served and they considered they had personal jurisdiction over me and I was never properly served, the address that they said, again, I never lived there. So I don't know who they sent it to, and they should be able today to show the proof of service. If he said anything about proof of service, I should be able to see that. Anything that he's saying that he have on me, I should be able to see it. Not him just sitting there just saying that he have proof of service and all. No, that needs to be, I need to be saying, he needs to let me see that, Your Honor.
And I denied your request for relief, Mr. Nesby. You'll be able to appeal that if you deem that proper to do that. What else were you asking from the court today?
Yeah, another thing was they had took money from my Social Security. I had sent in a hardship to try to get back where I can't even afford rent now. For the last
you're on SSI now?
No,
or
I don't.
SSDI?
Yeah, I have SSDI. They would not give me SSI.
Okay.
And I sent them a copy of it. It was $1,768, and all I'm getting from that is $618.
And Your Honor, bear in mind, I don't believe that this is the only order Mr. Nesby has. And so our records show, I think Mr. Nesby is absolutely correct. We show an SSD payment of $1,768 per month, but we show coming in on this cause, and I think the last indication I could find was in March, and it was $469.70 on this cause.
Can I respond?
Well, what I say may help you out, actually, Mr. Nesby, which is there's no doubt that if there are other orders floating around out there that exceed the statutory limits on how much cumulatively Mr. Nesby can have taken from his SSD, that is absolutely something that our office can look at moving forward. We just don't have access to that immediately, Your Honor. But on our cause, we are well below certainly the statutory limits, collecting essentially 1/4 of the SSD payment that Mr. Nesby gets.
Can I respond?
You may.
Okay. Yes, and also there was a lump sum payment that they also, he's not mentioning, that they took from me as well.
And when was that, sir?
I don't have the exact number because when I called to the Social Security office, I think they took it about a month ago. I think they paid out less than a month ago. They paid out the lump sum. And can I ask also what case number did they use to take the money from the Social Security?
I'm not sure. Do you mean Do you mean the case number, Mr. Nesby, of this cause of action?
No, well, the case number that they used to take, because the numbers that they gave me
was not the number of this case that was taken from Indiana to pay the lump sum to. So I was just curious what number did they do?
I don't know.
Got the whole 11,000? But they said they sent out payments. They said they sent out payments and they wouldn't give me the information that I needed.
Well, Mr. McDonald would have a record of any payments they received.
And I'm looking, Your Honor. I think the last calculation we did may have predated a payment that would have been made in March, or May rather. So Mr. Nesby, I do not want to dispute what you said, and certainly I can provide to you and provide to the court an updated arrears calculation that would reflect the payment of any lump sum. I'm absolutely happy to do that. We would only know, though, bear in mind, if we got the payment on this cause. If there were additional funds that went to other potential paternity cases or divorce cases, we wouldn't have access to that. But I'm perfectly happy to update an arrears calculation and get you an answer as to whether we received a lump sum payment. You will absolutely get credit for that. I've been doing this a long time, and I'd like to think that our office is, while we don't necessarily have a lot of satisfied customers like yourself, we certainly are pretty good at math, and we certainly want to give you every dime of credit you deserve, sir.
But Mr. McDonald, you're saying that could have gone to another cost number you don't know right now.
Well, you know what? I actually just received, that's the beauty of technology, Your Honor. It looks like my office manager, Tracy Tillman, is indicating that on 5/1, we received our office a lump sum payment of $1,604.07. So 1604.07. 1604.07.
And that was on May 1st of this year?
It was.
Okay. Not the 11,000 that Mr. Nesby thinks might have been taken, but that could have been applied to other cost numbers.
That's correct, Your Honor.
What we received here was the 1604.07.
Correct, Your Honor. That's right.
All right. Anything else, Mr. Nesby, that you want to argue today?
No, I don't want to seem like I'm arguing, but I don't want to argue.
Okay.
And I just want to be clear to Mr. Nesby in the court that if there needs to be now or in the future any recalibration of how much money we are taking towards the arrears, Mr. Nesby, we will absolutely do that. We do not want to take any more than we are supposed to be taking. We understand that you need to live.
Yeah, Your Honor, I don't know if you. I would also like to ask about, like I said, the hardship that I actually sent in about my my rent and just living expense is I'm not even close to it. Just receiving $600 because I'm not allowed to work. The doctor got me off where I'm not allowed to work because of my back, and so that's the only income that I have coming in.
And I appreciate that, Mr. Nesby. What we are taking is not above what would be the legal limits for that, at least in this cost number. And if there's cumulative cost numbers going out there, Mr. McDonald said he would take a look at recalculating, but right now we don't have any of that information. So if you have any other cost numbers or any of that information, I would tell you to provide it to Mr. McDonald's office and they will take a look at it.
Okay.
And from a dollars and I'm sorry, Mr. Nesby.
Are you okay?
From a dollars and cents standpoint, Your Honor, the last actual support order when there was current support still due was $661.44 per week. And by the way, that was established by private counsel at the time for the original petitioner. Just so Mr. Nesby knows, I mean, obviously $661.44 is a hefty order, and we are not, now that it's an arrears only case, taking anywhere near that amount. We are taking less than that amount per month that your order was per week. So we don't continue to take the same dollar amount that we did when there was a current support order that we do towards the arrears. That amount is lower. And again, we will absolutely look and see and figure out. And again, sometimes we don't get all the information that we should from Social Security. We're not Social Security. But if we find out that there is in excess of what you should be cumulative taking. I have no problem looking at adjusting the amount that we're taking, Mr. Nesby, to give you, to give you a break, to be able to live.
And I appreciate that.
Yeah, I mean, the sad part is whether you agree with the calculation or not, even at the current amount we're paying this off, it's not going to be paid off in either your, my, or the judge's lifetime, because I've calculated it out and it's 75 years. So I'm not optimistic I'm making it 75. Maybe Your Honor and Mr. Nesby are, but I'm not.
No, I'm at 72. 72.
Okay. Well, we're going to show for the record that Mr. Nesby appeared, that his motion to set aside, that he deemed an interlocutory appeal is denied, that his request to reduce is denied. He was informed to provide more information to the Child Support Office, and they will reassess or recalculate depending on the information that they get. Other than that, I don't know that there's anything else I can accomplish today. So I'll conclude the hearing at this time. Thank you both for appearing.
Yep, thank you.
Thank you, Your Honor. Thank you for appearing, Mr. Nesby.
Yep, thank you. Appreciate it.
Thank you. You did. I summoned for tomorrow.
State of Indiana versus Daniel Lee. Will the second, 2011 CM 2685.
Good morning, Mr. Will.
Hello, Your Honor.
All right, Mr. Will, it looks like you were supposed to be in court July 11th of last year, and you didn't come to court, sir. Where were you?
I was currently in Benton Harbor, Michigan, dealing with parole from getting released from prison.
Okay.
And I had a lawyer, Dallas Coleman, and he.
Coleman's here this morning.
I'm here, Mr. Will.
Yeah.
How you doing? How you doing?
Doing well.
Okay. Mr. Will, what is your address now?
I'm currently staying in a sober living home, 116 days sober. It's 70 Clay Street, Battle Creek, Michigan, 49017.
Okay. How long you're supposed to be at the sober home?
It's a 90-day program.
Okay. And where are you in that 90 days?
About a month into it.
Okay. All
Close
right.
to a month and a half, maybe.
Okay. Mr. Coleman?
Your Honor, I do have signed plea paperwork. However, the only thing that wasn't signed was probation paperwork.
Okay.
I would just need to get that back to Mr. Will. He and I have had some difficulties keeping communication because of the various places he's been. And his phone number has changed several times. But if he could provide the court with the contact information for the place that he's staying at, I believe we can get the plea paperwork signed and he could appear by Zoom if the court were to release him today.
What is a good number for you, Mr. Will?
It's 269-210-1570.
All right. So did you hear what Mr. Coleman had to say?
Yes, ma'am.
All right. So it sounds like the only thing that really needs to be completed is the probation paperwork. There's a plea signed, ready to go. So, you're going to need to call Mr. Coleman. Okay. And then he will get you that information and we can hopefully come back Friday and take care of this. You can do that on Zoom.
All right, thank you.
Do you have Mr. Coleman's number?
I sure do.
Okay. All right. Give him a call today and we'll be back then on Friday.
Judge, could you repeat the phone number that he gave?
Yes. 269-210-1570. Correct?
That's correct.
All right. Thank you.
State of Indiana versus Jess Elijah Maupin, 2409 CM 2191.
All right, and Mr. Maupin, you were supposed to be in court October 10th of last year, and you didn't come to court, sir. Where were you?
Your Honor, I ended up having a warrant that popped up out of Marshall County for child support. I ended up, because I was appointed a public defender, I ended up figuring I would need to hire my own attorney. So I went and talked to Hofer about hiring him as an attorney. He told me that I'd probably be arrested whether we get this dismissed or not, because I have video that I needed to take into Coleman or Hofer about getting this dismissed. But I ended up I just got out of Marshall County to take care of that first so we could come over here and possibly get this dismissed. Or he said,
so were you in Marshall County Jail last October?
No, I was not in Marshall County Jail yet. I was actually trying to figure out how to go about the court dates and which one to go to.
Then why didn't you call your lawyer?
I actually
had a hearing on October 10th and you didn't come to court and you had a lawyer. He didn't know where you were.
I was trying to obtain a paid lawyer. Hofer, I've talked to.
All right, so before we go any further, Mr. Coleman is here.
Okay.
If you can afford an attorney, I will release Mr. Coleman from representing you. Is that what you want?
I mean, if he's already on the case, I didn't know because I've checked my case and I thought that I didn't have a lawyer anymore because I missed the court date. I didn't know if he resigned himself from the case or whatnot. But pretty much like I have a video to take to my lawyer now that I can not go to jail if I go to court and then possibly get this dismissed, hopefully, because I mean.
Yes, I understand what you're saying. Okay. But Mr. Coleman is here. What I'm trying to understand is, do you have the ability to hire a private attorney?
I have the bond receipt that I still have the bond receipt because you appointed me the public defender, even though I bonded out. So I do have the $600 I can sign over to Mr. Coleman. I'm hoping to get released so I can take that to him.
All right. Okay. So
I do have the $600 bond receipt to sign over to him. Yeah.
Well, you wouldn't be signing that over to Mr. Coleman. You do have a public defender. So I'm going to leave Mr. Coleman on the case. All right.
Okay.
He is not withdrawn.
Okay.
But I need you to contact him. What is a good telephone number for you?
219-242-0267. That's where I'd be staying at. I don't have a phone number currently. I've been locked up since February.
All right. That was 219-242.
Yes, ma'am.
2467.
0267.
0267.
Yes, Your Honor.
Did you get that information, Mr. Coleman?
Yes, Your Honor. Thank you.
And what is a good address for you?
5405 West, 450 North. And I apologize to the courts for this being spread out and taking the court's time as well, Your Honor.
You understand there's a no contact order in place, correct?
Yes, Your Honor.
Okay. State want to be heard on Zoom or on bond?
Judge, I'm going to leave it to your discretion. He has a slew of charges that he's been through. Granted, nothing since 2021, but they're all, I've got failure to return to detention, charges of escape, which kind of questions as to his ability to come back to this court. And I think bond needs to ensure his appearance in court. He's also not a resident of Indiana. So I'd ask for a $1,500 cash bond in light of his history. 2106 F6 717 is charged to escape as an F6. And he pled guilty to that, but there were also charges of failure to return to lawful detention. So those are concerning.
Mr. Coleman?
Your Honor, he has posted, and I apologize, I don't have my file with me, but I think it was a $600 or maybe $750 bond. It sounds like he was taking care of some matter and was in court in some other county, I would ask the court to release him on his previously posted bond.
Your Honor, if I could, I am a resident of Indiana. I live in LaPorte, 5405 West 450 North. That's LaPorte, Indiana. Sorry, I don't know if I clarified that.
Thank you.
Yes, Your Honor.
Gonna set a $150 bond. And, we'll come back to court August 3rd. Mr. Coleman will want to talk to you.
Yes,
Okay?
Yes, Your
Okay,
Honor.
we can get things wrapped up then. Thank you.
Please and thank you, Your Honor.
Welcome.
Do you have, could I get the number, for Coleman to make sure that I got the right one?
Mr. Coleman?
Please and thank you.
Sure. It is 219
Okay.
219-9995.
Thank you. Appreciate it.
State of Indiana versus Sajaldeen Abdelnabi, 2404 CM 761.
Yes, sir.
All right, sir, you were supposed to be in court May 4th. You didn't come to court. Where were you?
Home. I miss no ride in that time, you know. I ain't got no ride, and I don't know how to take the
What is
train.
your address?
I stay with an old lady, you know, in Indiana, like 624 South Wayne Street, Gary, Indiana.
Okay, so that's where you're still living?
Yeah, I moved with her, you know, because she need help, you know. I know her for a long time. I used to check in her back and forth, you know. And now, last time I didn't give him the right address. That's why probably I didn't get nothing in the mail, you know. They didn't ask me what, you know, like if I missed the court, I get a mail or something from the court. And I tried to call like 4 times, you know, and nobody answered. One time after I missed the court, the sheriff answered me. I have to talk to the sheriff, and I told him, you know, I want to make a new court. And he said, call tomorrow. I will hook you with somebody, you know.
Okay, so looks like you were in court on March 16th, and you were told to come back to court on...
I never show up in court.
You were on video, okay?
No, I never. I was here since last 2 months ago.
You were on video on March 16th, and you were told to come to court May 4th. That's when you did not come to court. All right, so are you planning on hiring an attorney? Do you need a public defender? Did you wish to represent yourself? What is your plan here?
I don't know. I ain't got no money for attorney, you know. I mean,
Are
defender.
you asking for a public defender?
Yeah, it's okay. Yeah, that'd be nice.
Are you working?
No,
How do you support yourself?
help from a friend and the lady. I stay with the lady, you know. That's how I survive, you know. My brother sometimes, you know, help me.
What is a good telephone number for you?
219-614-7367. I can't work because I have a heart surgery, you know.
And whose telephone number is that?
It's me.
Okay. The court will set a $600 cash bond. I am appointing you a public defender, and we'll come back to court July 20th. Thank you.
So gotta pay $600 bond?
If you pay that, you can bond out, yes.
I ain't got no bond, that much money, you know?
Well, sir, you don't come to court, so I'm not just releasing you. I'll see you on July 20th Your attorney will be in touch with you. Thank you.
Okay.
I'll read you the charges and the possible penalties.
He is charged by way of information that alleges that on February 1, 2026, LaPorte County, state of Indiana, to the defendant unlawfully, knowingly, or intentionally operated a motor vehicle with 0.15% or more blood alcohol content. It was 0.166%. That's a Class A misdemeanor. Also charged with operating a motor vehicle while intoxicated. That is a Class C misdemeanor. The Class A misdemeanor is 1 year in LaPorte County Jail and a $5,000 fine. The Class C misdemeanor is 60 days in LaPorte County Jail and a $500 fine.
Mr. Ritchie, do you understand the charges and the possible penalties?
Yes, Your Honor.
All right, I'll enter a plea of not guilty for you, sir.
Thank you.
You're welcome. Are you planning on hiring an attorney to help you?
If I could have one appointed to me, that would be helpful.
I can give you a financial affidavit and have you take a seat in the back and fill that out. And then I can look at that. And if I can, I'll appoint you a public defender.
Thank you.
Mhm. All right, Miss Lewis.
Yes.
Okay. So are you looking for work?
No, I'm not.
Okay.
Working, being the fact that I've been attacked and injured and suffering car accidents and stuff like that. No, I'm injured.
And so right now you're living with family and friends?
Correct.
And they're supporting you?
Yes.
Prior to your injury, were you working?
Yes.
Okay. And where were you working?
I was doing cleaning work in Michigan.
Okay. A good telephone number for you is 219-210-8015.
Yes, ma'am.
Is that your phone?
Yes, it is.
All right. It is appropriate to appoint you a public defender. So I will set this for another hearing. That would be August 11th with Magistrate Link. That's next door. And that will be at 12:45. The Public Defender's Office will give you a call at this number. All right? You're welcome.
State of Indiana versus Derek Schwan, 2403 CM 665. Status of council hearing. Failure to appear, move for warrant.
If I may, this case was set over from Friday. He just needed to provide proof to me that he completed his substance abuse treatment, which he did. So this time I would add that the revocation be dismissed and released from completion satisfaction.
All right. Thank you, Ms. Ern. Then the matter is dismissed, released from probation satisfactorily.
Perfect.
State of Indiana versus Mark Allen Smith Jr., 2605 F6593.
All right, Mr. Smith, that's your signature?
Yep.
Okay. Do you have any questions about your rights?
No.
What's your address, sir?
5995 North Sherwood Drive, LaPorte, Indiana.
All right. If you listen to the prosecutor, he'll read you the charges and the possible penalties.
He is charged by way of information that alleges that on May 21, 2026, LaPorte County, state of Indiana, the defendant unlawfully, knowingly, or intentionally, in a rude, insolent, or angry manner, did apply pressure to the throat or neck of a person, being the victim, in a manner that impeded the normal breathing of the blood circulation of the other person. That's a level 6 felony. Level 6 felony is 6 months to 2.5 years, Indiana Department of Corrections, and a $10,000 fine with a presumptive sentence of 1 year. also charged with on that same date and time with unlawfully, knowingly, or intentionally in a rude, insolent, or angry manner did touch another person who is a family or household member by grabbing and twisting the victim's arm. That is a Class A misdemeanor. The Class A misdemeanor is 1 year in the LaPorte County Jail and a $5,000 fine.
All right, do you understand the charges and the possible penalty?
Yes, ma'am.
All right. Ma'am, are you the alleged victim?
Yes.
Okay. State?
Judges, these charges are only about a week or so old. We are not comfortable doing anything disposition-wise. We are asking for a no contact order, which is standard for an F6 strangulation and domestic battery.
All right. And ma'am, do you live with Mr. Smith?
Yes.
Who owns the home?
My father, well, my grandfather actually. Name.
Okay. Well, I am issuing a no contact order under these circumstances. That means you obviously cannot live together. You cannot have contact while this is pending. Do not contact Mr. Smith. If there needs to be information relayed, you're going to have to do that in some other fashion, but you cannot have contact with each other. So, Mr. Smith, you're going to have to find someplace else to live temporarily. Is there any place else you can go?
Yeah, for the moment, again.
And where is that?
I can live next door to there. That's
Who lives there?
my grandmother that owns the house that owns to us pretty much.
Okay. And what is that address?
Well, okay, so the one that you're speaking of is 5995 North Sherwood Drive and a half. And that is 5995 North Sherwood Drive without the half.
Are you planning on hiring an attorney?
Yep, Scott Paycheck.
Okay. All right. Ma'am, your name for the record?
Stephanie.
Pardon?
Stephanie Marks.
Okay. So, I'm going to ask that you go ahead and leave. All right. And Mr. Gallagher, you'll take Mr. Smith down in about 5 minutes when she leaves. Okay, very good. I will set this then for another hearing, July 13th. You can obviously have Mr. Pajek with you. We'll see you then. Thank you. Mr. Smith, let me get a good telephone number from you.
219-210-8446.
844?
6.
Thank you. Okay, and then we've got Mr. Ritchie. Okay, so how do you support yourself?
I have disability.
Disability, okay. And a good telephone number for you is 219-231.
Correct, Your Honor.
All right. It is appropriate to appoint you a public defender, Mr. Ritchie. I'm going to do that. I'm going to set it out a little bit. The public defender's office is very busy, and give them a little time to catch up and meet with you. We'll set this for August 24th.
Thank you, Your Honor.
You're welcome. Thank you.
State of Indiana versus Sergio Contreras, 2605 CN 1132. Initial hearing, Your Honor.
All right, Mr. Contreras, that's your signature?
Yes.
Any questions about your rights?
No.
All right. What is your address, sir?
7 Ash Street, Countryside, Illinois,
Okay.
60525.
All right. If you listen to the prosecutor, he'll read you the charges and possible penalties.
He is charged by way of information that alleges that on May the 7th, 2026, LaPorte County, State of Indiana, the defendant did then and there unlawfully, knowingly, or intentionally did possess an instrument, a device, or another object that the person intends to use for the introduction into that person's body of a controlled substance, tested the strength, effectiveness, or purity of a controlled substance, or enhancing the effect of a controlled substance. That's a Class C misdemeanor. The C misdemeanor is 60 days in LaPorte County Jail and a $500 fine. That is also charged with knowingly, intentionally, and unlawfully possessing marijuana, which is a Class B misdemeanor. Class B misdemeanor is 180 days in LaPorte County Jail and a $1,000 fine.
All right, Mr. Contreras, do you understand the charges and the possible penalties?
Yes.
All right. Mr. Galanos, would this be a case that your office would be willing to have a pretrial, per se pretrial?
I think so, Judge.
Okay. So, Mr. Contreras, due to the nature of the charges here, the state's willing to meet with you one-on-one to try to come to some agreement so that you don't have to go to the trouble and expense of hiring an attorney.
Okay.
They do that once a month. The next time they do that would be Thursday, July 16th at 8:30.
Okay.
That's on the third floor. That's where the prosecutor's office is. So we'll give you a reminder. So make sure you're there that day. Again, you don't have to agree with what the prosecutor suggests, but it gives you an opportunity to try to get this settled relatively quickly, okay? So make sure you're there.
All right, thank you, Your Honor.
Thank you.
State of Indiana versus Pablo Mezzo of Austin, 2407 F6944.
It's a $9.18 balance.
Oh dear. Well, let's just
Serious.
make that of record only. And that's it.
Yeah.
Well, we have one more gentleman here.
All right. So we'll dismiss this case.
And then
I call it clerk.
wait them.
Yeah.
We issued a bench one. Oh, I didn't catch his name yet. I'm still finishing the last one.
State of Indiana versus Donald Phelps. I think we called him and he's here. He said he had a flat tire, Your Honor. Pardon?
Yeah. Sterling.
Oh, Mr.
Sterling.
Sterling. Okay. Come on up, sir.
These people.
It's gone. Okay.
I think so.
It would. Was it it wasn't an initial, was it? Okay. Status of counsel, maybe? Yeah. Okay, Mr. Phelps, how are you coming on finding an attorney?
I've got an attorney that's going to represent me. His name's Shulman. I just got back to work, Your Honor. I was kind of like indigent for the last 3 or 4 months. And that was the problem when I discussed with the judge that was hearing your place. And I'm just not coming up with the couple $1,000 retainer that the guy wants. So I'm getting ready to have it. He's getting ready to sign on. So if we wanted to move forward, he would sign on and we can move forward unless there's a reason we can't move forward without him already being on the books.
So when do you think you're going to have your attorney hired?
Say 2 weeks at the most. I'd get paid again and I'd be able to.
So I'll withdraw the bench warrant and we'll set this for July 27th.
That's not good enough time.
Right. Thank
I'll
you.
definitely have him in touch with the court before that.
Thank you.
All right.
Mm-hmm.
Thank you guys so very much, and I'll see you. I left one of you guys a message. Sorry about that.
Okay.
All right. Okay.
Good luck with the call.
Guys, have a good day.
Thank you.
And who's the call?
Hey.
Once a year.
Yeah,
This happens.
see you.
It sounds like
COVID days.
You got somebody right there.
oh.
Mm-hmm.
Was it?
39 years.
Announcement clerk. Okay, recess.
Thank you, Judge.
Thank you. Gentlemen in the gallery, would you by chance be Luis M. Mendez Padilla? Okay, sir, why don't you come forward, please? Morning, sir. Okay, I was going to ask you because I did authorize a warrant for your arrest, but I'll
My son gives me a run, so.
okay, understood. We'll set the warrant aside, Mr. Well, let me recall the case 26 CT 190 Wisconsin versus Luis M. Mendez Padilla. Am I pronouncing your last name correctly, sir?
Yes, Mendez Padilla, you got it right.
Okay. So he's present. He's here without counsel. The state's appearing by Attorney Teurer. We're recalling the matter. Court will vacate that warrant authorization given the appearance, albeit untimely, and with reminder to the defendant to arrive at future proceedings more timely. So, sir, you were in court, on May 4th on this matter? Does that sound right? You went to court there and saw Commissioner Falk?
Yeah,
right.
mostly more or less.
Okay. All right. So, so you're charged with a crime, a criminal traffic offense. Do you want a lawyer? You have the right to a lawyer. Even if you can't afford one, I'll make sure you get one. That's how I have to start this out. So do you want a lawyer?
Oh, I don't think I can afford one right now.
Okay, well, that's the thing. Even if you can't afford one, you have the right to one. We'll still give you one. So you want one or?
Well, I guess I don't need one.
You don't think you need one? Okay. Well, that's a different consideration. Sometimes they go together, but Attorney Teuber, is there an offer that's outstanding?
There is, Your Honor. In this case, the state is recommending a 5-day jail sentence.
Okay. When I hear that, sir, I'm not telling you what the sentence is actually going to be because I don't really know. I don't know at all. But when the state says something like that, I feel like talking to you a little bit longer about your right to have a lawyer. And let me put it this: would you have any objection if I required that you have either a state public defender or a county appointed lawyer?
I don't think I need a lawyer, like I said. I just want to talk to you a little bit, like about my case and stuff.
Yeah, but sir, I can't. I understand that's a natural thing to want to do, but I can't just talk to you. I mean, I can talk to you in front of the prosecutor, but I can't. They make the offers. Like,
let's just go over the 5 minutes.
Are you sure about that? Okay.
Well, I'm not, I don't agree with that, but I mean, if I got no choice, I guess let's just go with what it is.
And I made a
No.
mistake, Your Honor.
Oh.
I actually said 5 days. I hadn't opened it. I knew it was at least a fifth plus. It's actually a 10-day jail recommendation.
Okay, so,
Then they,
well, that's what they're gonna recommend.
can I
sir.
get Hubert?
Well, we're getting ahead of ourselves. I think I can tell you that would be pretty likely, but I can't say for sure. And even if I say, hey, you can have Hubert, the sheriff's department might say, now that you're in our custody and we're in charge sort of your person, we're not going to give you Hubert because X, Y, Z. I don't see, this is now we're already making a record. So makes me kind of uncomfortable. So I think, you tell me if you agree, sir, I think you should at least talk to a lawyer. And if you ultimately want to represent yourself, you can, if you're worried about the money. Is that okay? What's that?
How do I get a lawyer?
Well, procedurally, I'll deal with that. The court system will make sure that you get a lawyer. Okay. So, yeah, because when the state's talking about that, and when they have the right to talk about that, it makes me uncomfortable to just have you represent yourself. So, so this is what you got to do, sir. If you're, well, yeah, so contact the public defender's office. It's the local office here in Jefferson. Call that office at 920-674-2800. You can also go to the office across the street there. Do that by noon today, sir. They will determine whether you're eligible for a state public defender lawyer. If they determine that you're not eligible for one, then that's where the county will provide you a lawyer. And yeah, you will have to make some effort towards repaying for the cost of the county appointed lawyer, but we're pretty accommodating when it comes to that. So here's the other thing that you got to remember to do before you leave the courthouse. Stop at the clerk of court's office, or this lady over here to my left, she'll give you a document called a petition for appointment of an attorney. So you fill that out. If you're not eligible for a state public defender attorney, then I will use that form to make sure you get a lawyer at county expense. Understand?
Yeah.
What's that?
Yeah, I understand.
Okay, so, and then we'll come back to court sometime in July or August. All right, and then if you decide, no, I think I still want to represent myself, we'll have to have an exchange. But if you're, if the law says that you understand what you're doing, then I'll let you represent yourself. So, come back to court, sir, on. Is there anything particularly inconvenient about Monday morning? Or?
No, it's fine.
Okay. What about Tuesday morning? Does that work? Tuesday, July 2nd at 8:45. Excuse me, Thursday, July 2nd at 8:45. Come back.
Thursday?
Yeah, it doesn't work?
It could be on Monday or Tuesday.
Sure. Tuesday, Tuesday, June 30th at 10:15.
June 30th?
Yes, sir. Tuesday, June 30th, 10:15. Have you used Zoom before? You don't Zoom? No? Okay. Okay. Are you still in Harvey Avenue in Watertown? Okay. All right. So, yeah, come back to court on Tuesday, June 30th at what time, Madam Clerk? 10:15. Okay. And then, so you got, by noon, you got to call the public defender's office. We'll put that number, a telephone number on paper, and then you have to stop at the clerk of court's office to fill out that petition as well. Okay. All right. Anything else, Attorney Toiber?
No, Your Honor.
Madam Clerk?
Nothing, Your Honor.
Okay, recess. Thank you. Yes, sir. Thank you. Be seated. Thank you. Morning, Mr. Hildebrand. So let's call 25 CF 77. That's Wisconsin versus William Hildenbrand. Mr. Hildenbrand is present. He's here with counsel. That's Attorney Peel. The state's appearing by Attorney Teuber. And Attorney Teuber, is there a victim rights compliance in place?
Yes.
Okay. Let's see here. So what's the status of the case, Attorney Peel?
Your Honor, I don't think my client's capable of making decisions on how he wants to proceed. That's the issue I'm having right now. That's where I'm at.
Okay, is that a competency thing?
I know competency was challenged in the beginning. I think there's still an issue with respect to that. I just don't know if he can make a decision. We tried to discuss the options, and I don't think he's mentally in a state where he can actually make that decision of what he wants to do. So I can't tell the court what he wants to do. So I don't know where to go from here, Judge, but that's where I'm at. I mean, we discussed the different options of having a trial or a court trial, or you know, withdrawing his plea and doing the NGI. I just don't think he can make the decision. And I think that, you know, this might be a reason to reevaluate competency, Judge.
Okay, that's where I was leaning. What did you want to say, Mr. Hildebrand?
Just to clarify, my inability is rooted in my brain doesn't have a guilty conscience about what I'm so sorry about it, but I never decided to do something wrong. And so because of that, I feel like I'm being asked to engage in something that I can't consent in, because either way feels inappropriately damning to me, because I feel like the court is being allowed to look past the officer's aggression when approaching me, knocking on my window saying, "Step out." I turned and I blacked out, and I never decided to put my car in gear and start it. But that's what I did. And then when he broke chase, I went down to speed and I went home where they were waiting for me, and they surrounded me with guns, laughing, and they broke me out of my car and they maced me and they tased me and they evicted me. In fact, I'm so sorry. I'm sorry.
Mr. Hildebrand,
I'm trying to
yes, sir. Yes, sir. Yeah. So now, if the court has any reason whatsoever to question legal competency, then the court has an obligation to raise that. And it doesn't matter if there's been an evaluation once or more than once. Between Attorney Peel's record, my own assessment of the other remarks and tone and tonality and temperature in general, I think that there's good reason to order another competency evaluation, so the court will make said order. Mr. Hildebrand's to be examined again for legal competency purposes. Attorney Peel will draft an order requiring that assessment, and I think we already did the NGI and competency thing at the same time. Do you think should we run on that tack again?
I think we just need to do competency here. I think NGI is clear, Judge. I think both sides agree. Okay. I mean, at least when I was...
if we can trust to his insight, he seems to be suggesting NGI.
That's so exactly correct.
Keep that parked. Well, let's see. I just want to make procedurally, I shouldn't be doing anything on that for sure, or competency evaluation. Okay, so you think we have to do anything else on NGI, Attorney Peel?
No, I don't think so right now, Your Honor.
Okay. would you want to add anything to the record, Attorney Toiber?
I would just note that our office does agree with the NGI finding that's already been done, and then understand that the court is raising competency.
Okay. Oh, that's right. Did Dr. Freiberger already examine for NGI?
Yes.
That was my oversight. Okay, so that's already.
Yep.
We're good to go on that. So Attorney Peel, I think we should probably come back in 60 days, maybe by Zoom, if that's okay with
That's fine.
Is that okay, Mr. Hildenbrand?
Thank you.
Okay. Let's see. So we're gonna have court again in early August. Let's come back to court, so to speak. We'll reconvene on August 10th at 10 a.m. Monday, August 10th, 10 a.m.
Could you do a half an hour before or half an hour after? Because I have a Zoom in Outagamie County.
Sure. 10:30 on Monday, August 10th. Status concerned with the results of any competency evaluation, and then we would go from there if we need a hearing on that opinion. And sight and sound sufficient Zoom is okay for those proceedings. And I think we can wrap it up for today. Let's see here. Mr. Hildenbrand, you still in Antigo?
Yes, I am.
Okay. Yeah, 202 Hudson Street.
But for now, and
okay.
I'm looking at moving into a healthier situation. Well, just not healthier. It's not an unhealthy situation. It's temporary.
Okay.
I'm looking to move into a
all right
transition for the state. Working with the ADRC in Wisconsin.
Okay, just make sure you let your lawyer know if you change your address. Okay. Okay. All right. Recess.
Thank you.
Thank you.
All right, so a drug abuse surcharge is applicable. That's 75%. So on a $250 fine, that surcharge should be $236.25.
I'm sorry, 236.75.
$236.25.
All rise.
Seated. Thank you. 25 CM6 Wisconsin versus Magdalene K. Stone. Ms. Stone is present with counsel, Attorney Ginsburg, and the state's appearing by Attorney Toiber. We are here for a projected change in plea and sentence. I have a criminal case settlement form. Does that contain your signature and your client's signature, Attorney Ginsburg?
Yes, Your Honor.
All right. Also on file, a plea questionnaire and waiver of rights form. This is document 43. So Ms. Stone, did you go over a document called a plea questionnaire and waiver of rights form with your attorney?
Yes.
Okay. Did you understand everything in that form?
Yes, Your Honor.
Did you sign that form?
Yes, Your Honor.
All right. It says that you're 24, that you have 16 years of school. I'm just going to ask you some questions I think I'm required to ask you, like, do you have any difficulty with the English language?
No, I don't.
Are you prescribed any medications for anything of a mental or emotional nature?
I am.
Okay, so what sort of condition? Could you tell me
I'm
that?
prescribed lorazepam for anxiety.
Okay, you're taking that as prescribed?
Yes.
What's the name of that drug again?
Lorazepam.
Lorazepam. And now this is very important, Ms. Stone, these constitutional rights listed on the form, your right to a trial, your right to remain silent, your right to testify, your right to use subpoenas, your right to a jury trial, your confrontation right, and your right to make the state prove your guilt beyond a reasonable doubt. Did you go over each one of those rights at length and detail with your attorney?
Yes, Your Honor.
Do you intend to plead guilty to this charge of possession of cocaine?
Yes, Your Honor.
That's count 3. If you do that, and if I accept your plea, I'll find you guilty, and then there will be a misdemeanor criminal conviction that attaches to you for that offense. Do you understand that?
Yes, Your Honor.
Okay. Did anyone threaten you or pressure you in any way to get you to give up your rights or sign anything or say anything?
No, Your Honor.
Attorney Ginsburg, are you satisfied that Ms. Stone's in a position to enter a plea here that's knowing, free, voluntary, and intelligent?
Yes.
She understands did you discuss the elements with her?
Yes.
So she understands the nature of the allegation, the maximum penalties, and her constitutional rights?
Yes, Your Honor.
And she sufficiently appreciates the implications of her plea and the conviction?
Yes.
And is there a sufficient factual basis before the court for a plea to that third count?
Yes.
Okay, so Ms. Stone, you wish to enter a plea now?
Yes.
All right, just wanted to confirm that. And what's your plea to count 3 possession of cocaine?
Guilty.
The court receives that guilty plea, and upon that plea, the court will find the defendant guilty, adjudge that she is convicted, and direct entry of judgment accordingly. The court is satisfied that the plea is knowing, free, voluntary, and intelligent, that Ms. Stone understands the nature of the allegation. She understands what the maximum penalties are, the implications of her plea and the conviction. And there is a sufficient factual basis before the court for a plea to that 3rd count. As to count, well, it's going to be 4 and 5. There must have been a co-defendant. In any event, the other charges in this, do you want to make a motion, Attorney Toiber? That's what I'm trying to say here.
I do, Your Honor. I think the original CCS had some errors on it. We tried to correct it, but as to any remaining count related to this defendant, the state moves to dismiss and read in.
Okay, anything else on that, Attorney Ginsburg?
Yes.
Something else on that?
Oh, I'm sorry.
Yeah, nothing.
I thought you said anything, nothing else, and I said yes.
Okay, so I'm going to grant that motion. And what is this note here? Did counsel ever submit an order to seal?
I submitted a document from a treatment provider when we were still begging and groveling to reinstate the first offenders program, and then we sealed that. So there was a document talking about the treatment that she'd been doing for the past 6 months or a year.
Okay, so did you, whose court was that in? My court or your court? Motion to seal on May 6th. Okay, that looks like it's in good form and expected form. There's a temporary seal on the document 34. Oh, yeah, you need to submit a proposed order then. I'm granting it in principle, Attorney Ginsburg, but you need to submit a proposed order. No, you don't. So I'm granting that order. Let's see what we're going to seal. Document number 34. It's a wholesale seal. It's no redaction. Document 34, except for page 1, because that's the cover letter. No, that should be sealed too. Just seal that whole document, Madam Clerk, okay?
Yes, sir.
Thanks. And let's see here. The state's recommending a fine, Attorney Toiber?
That is correct, Your Honor. I believe it's a joint recommendation of the parties. I would note the defendant started in first offender program, but did have recent law enforcement contact that did lead to the revocation. That is the reason for the fine only outcome here.
Okay, Attorney Ginsburg?
Yeah, I hope that the court's willing to just impose a fine. We were trying to do everything we could to get her back into first offenders to try to avoid a conviction. That wasn't successful. And at some point, she's only 24. And so I was then hoping maybe probation and expungement. And the state really was not in favor of expungement unless we pled to more crimes. So at this point, the simplest, cleanest way is just to plead to 1 misdemeanor count, pay a fine. Ms. Stone wanted to leave the state anyhow. At this point, probation would have been onerous because she works mostly in another state anyhow and lives up in, her folks live in Juneau County. So it's the stigma is the conviction. For a person who has no convictions, we always try to avoid them. So at this point, a fine is sufficient for a first offender who's young for just possession of a cocaine.
Okay, Ms. Stone. Oh, Attorney Toiber?
Sorry. Before the court would to get to the defendant's allocution, can I just make one additional comment?
Certainly, yeah.
Since the issue of expungement did come up, ideally we would consider expungement if someone was simply revoked from the first offender program and there was a way to keep her record clean. I think it's important for this court to know she does have an open OWI offense in Iowa, and then she does have a federal indictment, which is why expunction is not being recommended on this fine only outcome.
Okay.
Well, she doesn't have an indictment. Apparently, the boyfriend she was living with, I know all the details. There was a fire in an apartment, and when the fire department got there, there was a grow operation or something going on. The boyfriend's, was indicted by the feds. So the state is aware that they were looking at if Ms. Stone had any involvement also, so
Okay.
they were just dating. Oh, they weren't dating.
Okay.
Anyhow,
Well,
there was enough background problems because she got that OWI and didn't report that. This is where we ended up.
okay. Ms. Stone, is there anything you want to say before the court sentences you?
I am really sorry that the first offenders program did not work out, and I really would like to move on with my life and be
Okay.
done with all this.
All right. Well, truth be told, I think the court should probably adhere to a probation result. I mean, just because that's where it's supposed to start, but it doesn't have to be that way. Is it just a matter of logistics and inconvenience that she doesn't want to do probation, Attorney Ginsburg?
Well, there's a lot more. As I said, her folks lived up in Juneau County. She works in the state of Iowa. Even today, if we'd have done probation, they wouldn't have given her a travel permit. She would have missed work. She wants to go to Florida. Truth be told, Judge, if she were on probation, if the carrot would have been expungement, we were thinking of it. But at this point, you know, if the proper outcome might be a fine, if somebody's on probation, God forbid anything goes wrong, you could sit in jail for 2 or 3 months in a heartbeat. And so that's really why we're here.
Okay, I get that. I get the practical implications. I'm just telling you the way they train me, they train judges is, hey, you start with probation, and unless the person rejects it, you know, unless it unduly depreciates the gravity of the offense, and there's some other principles in operation, then it's where you start and that's where you end. But I think we have a record here that's sufficient to I'll use the word overcome that. I don't know if what I heard from Attorney Ginsburg equals a rejection, but in any event, I don't think a fine result unduly depreciates the gravity of the offense. I mean, it's I think there's some AODA issues. There could be some there. That might be an understatement. But then I'm hearing about these other cases that have AOD implications too, and we'll trust and/or hope that those are evaluated or considered in those other cases. So the court is, we're going to pursue primarily or perhaps even exclusively deterrence and punishment for in terms of the substance, in terms of the offender's involvement here, kind of a mid-grade, low to mid-grade. Certainly significant, but you know, we can all make distinctions between cocaine and other things like meth and heroin and fentanyl. So, but if Ms. Stone, ma'am, if there's anything, I think you have insight into there's a chance you have insight into any challenges you have like this. Don't, you know, I'm going to just stop there and fine Ms. Stone $250. She'll also have to pay statutory costs. She has to comply with DNA sample provision requirements and then pay the surcharge, which is $200. And she has to pay, she's responsible for this $50 drug testing fee. Yeah, that doesn't unduly appreciate the gravity of the offense. We're going to deter. That's her primary goal here. I have, you know, sense that there's some rehabilitative needs here, but party urging, not going to prioritize those. She seems to be of good character for criminal justice purposes. And so what does she owe, Madam Clerk, when we have that fine and then all those other things that we have to collect?
There was discussion off the record of an additional surcharge.
Additional surcharge.
Idiot Toiber.
I believe when there's a fine ordered on a drug-related conviction, there is additionally a drug abuse surcharge that gets added. That would be part of the normal court costs and fees. I brought that up to the clerk. I think the clerk's office would just have to verify whether or not that's accurate.
Well, I'm going to voice it like this. So she has to pay the fine. She has to pay statutory costs. She has to pay the DNA surcharge and the drug testing fee, and she has to pay any other cost or surcharge that the law requires the court to require her to pay. Is that okay, Madam Clerk? I mean, for your purposes.
Yes.
All right. Can you pay that within 6 months, Ms. Stone?
Yes, Your Honor.
Whatever that, well, what's that total, Madam Clerk? We suppose we should verify that.
So pending verification of the drug abuse surcharge, the total would be $1,290.50. 88 Toiber voiced that amount to be $236.25.
That 250 sure adds up, doesn't it?
Well, it does, yeah. That's not, yeah.
Off the record. I know that on a drug conviction, there's a 50% surcharge that I've been doing for years. Yeah, 50%. The DA thinks it's 75, but.
Yeah, I've just verified it's 75 if I can trust what I'm.
Right, then I think that's where we're at.
Okay.
75% of the fine.
I'm sorry, 75% of the combined base fine and penalty surcharge on any drug-related conviction. The court cannot waive or reduce this amount. Funds go directly to the state. Oh, okay. Anything else, Attorney Ginsburg?
We are.
So Ms. Stone, you have the right to appeal this case. Discuss that right with Attorney Ginsburg and make sure you know what the deadline is. Okay. And yeah, pay that. Oh yeah, Madam Clerk is looking at me because I didn't fix a date and time. I didn't fix a date for which.
30 days.
Good. 30 days. Okay. Let's see. Let's make sure July 8th is a business day. Yep. July 8th, 2026. Make sure you pay that total amount, Ms. Stone. If you don't, then you have to go to jail for 5 days and then you'd still owe the money. Okay.
Thank you, Your Honor.
Yes, ma'am. Anything else, Attorney Toiber?
No, Your Honor, thank
Okay,
you.
Madam Clerk?
Nothing, Your Honor.
Okay, recess. Thank you.
Thank you.
Do I have something to do?
Yep, it's in there.
Perfect. I think.
Attorney Ginsburg, good seeing you.
You asked to move this up because.
Yes.
To do that DNA thing in person.
Oh, to do it locally. I appreciate that.
Do it by Zoom,
that-
but then you would go get the surcharge. You would add to show us your enemy.
That's true. Yeah, that's very considerate. Thank you, Attorney Ginsburg.
This is what I was thinking of.
Yeah, that's
Okay.
chapter 943.
Right, court will next open the record in 26 CR 9, People versus Lane Nicholas Rothman. Mr. Rothman appears by WebEx from the Backey County Jail, is assisted for today's purposes by Ms. Madeline Almond. Ms. Esch on behalf of the people. Ms. Almond, are you similarly able to waive Rule 5 advisement for Mr. Rothman?
Yes, I am, and I do so at this time.
Thank you. Court accepts that, and we'll move to the issue of bond. This was a menacing allegation, so the court determined to set bond at this first appearance. Ms. Esch, the people's position on Mr. Rothman's bond.
If I may share with the court the video that was formed the basis for this charge. Can the court see that?
Yes.
Okay.
I will, you fucking kids with their fucking motorcycles. You drop that gun. You drop that fucking gun and see what happens. Threaten my fucking son again, you piece of shit. I didn't threaten your son, motherfucker. Fuck you, Michael.
Have some consideration.
Mr. Rothman has no criminal history, and the people don't believe he's a flight risk, but I've looked at a lot of menacing cases, and this one is probably one of the more serious ones that I've ever seen. I had great concerns about whether or not his anger in that moment might have caused the trigger to slip. That gun was pointed directly at Mr. Rao. Mr. Rao is very upset and concerned for his safety and his family's safety from this incident. Because of the gravity of the facts that are depicted in that video that we'll later deposit as People's Exhibit A, the people would ask for bond to be set at schedule. We would also ask the court to consider some kind of GPS restriction, or that was Mr. Rao's request, to make sure that the defendant does not go anywhere near Mr. Rao's address, which is listed on the protection order. We'd also ask that a condition of bond be compliance with the protection order.
All right. Thank you, Ms. Almond.
Yes, Your Honor, we would be asking for a personal recognizance bond today. As noted, there were no previous cases. This is Mr. Rothman's first arrest. He has no failures to appear. He's lived in the region for most of his entire life. He's lived at his current address for the last 7 years. He has a vehicle and a driver's license to be able to make to and from court. He is currently employed. He manages for his father's construction company and he has been doing this steady for the last 8 years. And he is missing work by being in custody today. He has family that lives in Springfield. He lives with his wife and his 3 sons, his youngest son being 4 years old. Needs to be able to be there to help care for them and to be able to continue working for them. Currently, he believes that he would still have a job when he gets out, but if he is kept incarcerated for a lengthy amount of time, he may not be able to return back to work exactly as he was previously. And so considering all this, considering the low CPAT score and the no criminal history here, we'd be asking the court to issue a personal recognizance bond. We have nothing to add for the protection order here, but that would be our request today. Thank you.
Thank you. The court has considered the purposes of bond. The CPAT-R filed on behalf of Mr. Rothman does indicate a score of 0. The court, this court was the one that reviewed the affidavit, and there was an amended affidavit that I would just also flag for counsel. It doesn't change anything super substantive other than a statute number and sort of clarifies a portion of another officer's narrative. But again, this is the second case of the day in Backett County where a gun is involved, and just an extremely precarious situation where, one split second could have significantly changed the outcome. This court understands that Mr. Rothman is not a flight risk. He has significant ties to the community. However, what he's accused of doing does present an extreme safety risk to the community. So I don't believe that a personal recognizance bond is appropriate. However, I do believe that a downward deviation from the bond schedule is appropriate. Rather than a $4,000 bond, the court will issue to Mr. Rothman a $2,000 cash or surety bond conditioned upon full compliance with the protection order. And this protection order is a no contact protection order. So at this point, I'm not going to issue a GPS monitor requirement for Mr. Rothman, but it will require that he not have any contact with Mr. Rao. Mr. Rothman, you should have a copy of that protection order there in front of you. You'll see that it lists you as the restrained party, Mr. Rao as the protected party. It orders that you not harass, molest, intimidate, retaliate against, or tamper with any witness to or victim of the acts you are charged with committing. That you refrain from contacting or directly or indirectly communicating with the victim or witness. Lastly, on the second page, number 8, you shall not take, transfer, conceal, harm, dispose of, or threaten to harm an animal owned, possessed, leased, kept, or held by the victim or witness. I do see Mr. Rothman, there's an error on this protection order. This is not an act of domestic violence. It indicates that it is, but that we'll send over an amended protection order for you to sign that indicates it is not domestic violence related. Aside from that, Mr. Rothman, do you understand the conditions of that protection order, sir?
Yes, Your Honor, I do.
All right. If you were to violate any of those conditions, you'd be charged with an additional criminal offense of violation of a protection order, which is a Class 1 misdemeanor, punishable up to a year in jail and or a $1,000 fine or contempt proceedings. Do you understand that, sir?
Yes, Your Honor.
All right. Then once we get you that amended protection order, Mr. Rothman, I'm going to ask for your signature on page 2. You'll see my signature on page 2, and then I'll ask for your signature on page 2 on the line labeled defendant. That is not a confession or admission of any guilt necessarily. It's just indicating that I've explained this order to you, you understand it, and you understand the consequences if it is violated. Do you understand your bond, Mr. Rothman?
Yes, Your Honor.
All right. Mr. Rothman, for purposes of today, because you were in custody, you automatically qualified for court-appointed counsel. If you are out of custody and you make bond, you are free to either hire your own attorney or to apply for court-appointed counsel if you believe that you would financially qualify. If you wish to apply for court-appointed counsel, you'll need to fill out an application. You can do that there at the jail, and they will then submit that to the public defender's office to see if you qualify. If you do, I'll then appoint an attorney to represent you. Understood?
Yes, Your Honor.
All right, Mr. Rothman, your next court date is going to be Monday, June 22nd at 10 o'clock a.m. You need to be present in the Baca County courtroom on that day and at that time.
Yes, Your Honor.
All right. If there's nothing further from either of the attorneys, then I will excuse and remand Mr. Rothman and close the record in his case. Thank you.
Well, I thought I'd write a happy song. I found a chat room where I belong. You don't know how much it means to me. With such a groove, I'm less lonely. Oh, Kathy's the creator. She's leading the way. At Court Vibes, we laugh and we stay. Her smile shines bright. She's got that grace. Come join the fun. It's a welcome and play. I can count on distraction from my pain, 'cause this creator takes you there and back again. Kathy is the heart here, always in stride. Her work is hard, but her joy she can't hide. Oh, Kathy's the creator, she's leading the way. At Court Vibes, we laugh and we stay. Her style is classy, she's always top shelf. Don't take my word, come and see for yourself. Her cases are new with a twist or two. I really like them, I believe you will too. A little lifeline passed along in rhyme. Why don't you join us? It's a guaranteed good time. Oh, Kathy's the creator, she's leading the way. At Court Vibes, we laugh and we stay. Her smile shines bright, she's got that grace. Come join the fun, it's a welcoming place. And so in conclusion, I'll wrap up this song. I hope I didn't miss anything that would be wrong. Hope I see you around. Don't stay on the shelf, join in the laughter. Come and see for